made this point in our filing of Wednesday last week. Indirect co-perpetration under Article 25(3)(a) is not the only mode of liability open to the Chamber in this case. We have filed a Regulation 55(2) application, again very early in the case, at the first available moment, for the Chamber to give formal notice to the accused that Articles B, C, and D were in play in this case, so not just 25(3)(a). We've given the defence further notice with respect to that issue in the pre-trial brief. So that's point number 2. And point
Mr. Lowry, may I interrupt you
yes,
with the permission of the presiding judge? On your first point, it can well be that the prosecution has a different view on the essential contribution requirement, but don't we have to look at the confirmation decision and the theory on which the pre-trial chamber confirmed the case, the charges against Mr. Kenyatta in this case, and don't we have to take it from there rather than from the point of view that you now are forwarding as the prosecution's point of view?
And if I may add, Mr. Lowry, we are now discussing the validity of confirmation of charges itself. So as Judge Van den Wingert said, that we really have to start with the interpretation of given by the pre-trial chamber in its confirmation decision.
Thank you, Madam President, Judge Van den Wingert, for your questions. The short answer to the question is no. We do not believe that the trial chamber is bound by the pre-trial chamber's view of the law with under 25(3)(a). If that were the case, there would never be the possibility for the law of this court to evolve beyond that which the pre-trial chambers set down in their confirmation decisions. So the pre-trial chamber, not the trial chamber, not the appeals chamber, would be the beginning and the end of defining the law at this court. And we say that cannot be right. Of course, Madam President, you're right that with respect to the Article 64 application, the starting point has to be the confirmation decision. But there, this brings me to the third point and last point I will make in response to the question, which is this. Even if you assume that the pre-trial chamber's view of the law is correct, assume that an essential contribution is required under 25(3)(a), an insufficiency of proof with respect to one alleged co-perpetrator does not necessarily mean that there's an insufficiency of proof with respect to the other co-perpetrator. So the withdrawal of charges of one alleged co-perpetrator does not necessarily mean that the mode of liability fails as to the other. Thank you, Your Honor.
At the same time, considering the current stage of the proceedings, does prosecution don't think that it is appropriate for the prosecution to seek an amendment of the charges against Mr. Kenyatta if prosecution would like to seek different forms of participation?
Thank you, Madam President. To dispose of the Article 64 application, no, we do not believe it's necessary to seek a formal amendment. That application can be disposed of assuming that the current mode of liability, 25(3)(a), indirect co-perpetration, holds. You can dispose of the application even if you assume that to be true, and I can get into the substantive arguments why later on. If Your Honours wish for there to be a formal amendment of the updated document containing the charges, such that Articles 25(3)(b), C, and D are included, we certainly wouldn't object to that. The key is obviously that the defence are on proper notice. We submit that they already are, but if the Chamber would like us to amend the charges such so as to add those alternate modes of liability, we would certainly have no objection, Your Honour.
We wanted to have a more specific answer to the question from the following perspective, because in the confirmation decision, the role of Mr. Mutuara was described as being an essential contribution to the common plan, a conditio sine qua non without which the common plan would not have been realized. Now that the charges against Mr. Mutuara have been dropped, how, in your view, does the common plan stand because of the fact that this essential contribution has been withdrawn, so to speak?
Fair question, Your Honour. In our view, now that the charges against Mr. Muthara have been withdrawn, obviously the focus of this case is now Mr. Kenyatta. The question is, what was Mr. Kenyatta's contribution to that common plan? Whether it's essential, as the pre-trial chamber suggested, whether it's less than essential, as we have suggested in our submissions on the law. Whether or not Mr. Muthara had an essential contribution to the plan, that's not what Your Honours will need to decide in this criminal trial with Mr. Kenyatta as the defendant. The question for Your Honours in this criminal trial is whether Mr. Kenyatta's contribution was essential or something less than essential if you decide to depart from the pre-trial chamber's view of the law. So the common plan, the allegations as to the scope of the common plan, Your Honour, they remain. It's just now that your focus shifts from contributions of two accused to the contribution of one accused. And whether or not Mr. Muthara's contribution was essential is neither here nor there at this point. Thank you, Your Honour.
Doesn't that depend on what we understand the word essential to mean? Can you have two people who are making several contributions to a plan, have those several contributions be essential to the realization of an objective? I think that would be the question, isn't it?
Thank you, Your Honour. Well, you're right. It does depend to some degree on the analysis of the law that the chamber takes, whether a contribution be essential or something less than essential, which is what we believe it is if one looks at the underlying scholarly works that underpin the pre-trial chamber's control of the crime theory. But under any analysis, the key is to keep focused on what your determination needs to be in this case. It needs to be what was Mr. Kenyatta's contribution. Let's take Lubanga, just as an example. In Lubanga, in the trial judgment, the trial chamber named co-perpetrators. They found that they were co-perpetrators. But that judgment does not include findings that the contributions of those individuals were essential. The trial chamber found, quite rightly, in our view, that as provided Mr. Lubanga's contribution was essential, under the trial chamber's understanding of that term, that was sufficient for a conviction to be entered. And that's our position, Your Honor.
In the Lubanga case, were there two people charged with essential contribution, or two people contemplated to have made essential contribution?
Yes and no, Your Honour. Lubanga was obviously a one-defendant case with just Mr. Lubanga. However, there was an accused essentially charged with the same criminal transaction, Mr. Ntaganda, who was also charged as a co-perpetrator, who obviously was not standing next to Mr. Lubanga at trial because he was and is on the run. So, no, not in a formal sense under that document containing the charges, but in reality, yes, Your Honour.
Well, last question from the bench. With reference to paragraphs 4 to 10 of prosecution's observation of 13th March, prosecution's position is that the essential contributions of alleged joint perpetrators who are not jointly charged do not need to be proven. In that case, is the prosecution relying on the presumption that these contributions could be proven if the person were charged? And is this presumption rebutted in the current circumstances where the charges against Mr. Muzala have been withdrawn on the grounds that there is insufficient evidence? I understand that the prosecution has partially already answered to this question, but still the bench would like to hear the full answer to this question.
Thank you, Madam President. Just making sure I get the question right. There's a short answer to it, and the answer is no. We do not believe that, as a matter of proof, we're required to prove essential contributions of non-charged co-perpetrators. If that were the case, Your Honours, these cases would be as much about individuals who are not in the courtroom as it would about individuals who are in the courtroom. It's our submission that the case should focus on the defendant and his or her contributions, whether they were essential, substantial, significant, middling, whatever word the trial chamber wishes to attach to those. But the focus should be on the accused, Your Honour.
I apologize for repeating myself, but it then means that there is no consequence to be attached to the fact that Mr. Mitaura's case has been withdrawn, who was alleged to have made an essential contribution to the common plan, which would have been frustrated had he not contributed. Does that not change the case? Does that not oblige the prosecution to reconsider its charges?
Thank you, Your Honour. No, we do not believe it necessarily changes our case, no. Again, the focus must be on the accused in the courtroom. If there were a necessary knock-on effect when the charges are withdrawn against one indirect co-perpetrator, if we take that logic to its necessary conclusion, it would mean that in every case where we have multiple accused charged under a co-perpetration theory, decisions would have to be taken in lockstep with relation to those accused. So if you had a case with 3 alleged co-perpetrators, all charged under 25(3)(a), and the chamber found that there was insufficient evidence as to one that warranted an acquittal, it would have to find the same with respect to the others. And in our respectful submission, that cannot be right, Your Honour. That's our submission. I hope that answers your question, Your Honour.